Good afternoon, everyone, and welcome to our webinar on sponsoring employees, tips in hiring skilled workers from overseas. Thank you for joining us today. My name is Cassandra, and I'll be your moderator for today. I'm joined with Alex Walk, Christopher Chang, and Tomami Matsuzawa. If you have any questions today, please submit them via the chat box on the bottom left of your screen, and we will endeavour to answer as many possible throughout the presentation. I will now hand you over to Alexander to begin.
Welcome. It's my great pleasure to welcome you to our webinar, Sponsoring Employees, Tips on Hiring Skilled Workers from Overseas. Thank you to the New South Wales Business Chamber who invited us for this webinar today, and I'd like also to introduce Tomami, our Senior Registered Migration Agent, who actually acts on behalf of a lot of small and large businesses across a range of industries, managing their approvals as business sponsors and their migration matters of their staff. Chris has joined us as well. Chris is our in-house corporate lawyer. He's also the Solicitor Director of our affiliated independent law practice, Migration International Legal, that provides legal services to domestic and international businesses who wish to establish operations in Australia or, of course, to sponsor their employees. My name is Alex. I'm the Director of the Migration International Group, and I hope we can give you today a lot of tips and insights on how to sponsor successfully employees for your business and what may be the best visa class to progress with the sponsorship in the future. Of course, I would like to suggest, if you have any questions, we're here at the end for a question and answer session. But if you feel it's important to address a question immediately, I think you can key it in on the left side, and we try our best to respond to all questions. A little bit about ourselves. Creating liberty to move has been our mission since our founder laid the cornerstone for the Migration International Group in 2008, with the first office actually in Sydney. Sydney Migration International is the Australian headquarters of the Migration International Group, and we are specialized to serve small and medium-sized business. So our focus is on employer sponsorships and small and medium businesses, maybe even with a greater focus on businesses in South Wales. We are also a proud sponsor of the Australian Migration Agent and Immigration Lawyer Association. How to interact? I just mentioned that. You can key in questions during the presentation, but we would prefer to have a question and answer session at the end, just to have a little bit of structure today. We will now go through the agenda. The purpose of this webinar today is to highlight common issues around the current 457 program. I'm pretty sure most of you have come across the term 457 visa, to provide tips on ways to overcome those issues. Of course, to provide information about alternatives to the 457 scheme, criteria, pros and cons, and maybe, hopefully, to assist you in understanding your implications as a sponsoring employer if you are already a sponsor. We will now load quickly a poll. We would be interested whether you are already sponsoring employees in your business on a 457 visa. Yeah, thanks for your participation. I can see it's pretty balanced actually. Give it a further couple of seconds. Some of you are still quoting. So we have currently actually something in the range of, still moving here, roughly probably 60% of you, yeah, or maybe even half of you, 55% of you have already sponsored an employee, and 45% have not sponsored an employee, which is pretty balanced. So I'm stopping the poll now. I hope we can actually provide a little bit of insight and tips for both of you, if you're new to sponsorships and if you're already sponsored. The 457 is the visa class, subclass 457, issues and tips. Let's approach this topic. The 457 is the most commonly used path for employer sponsorships in Australia. Australian Government Subclass 457 quarterly report ending last year in September actually shows a little bit of insight who is using those 457 visas, which industries. And here's a little bit of background information. So the top 3 areas we're talking about in terms of application granted. So 15% roughly, or 16.4%, are for managers, professionals almost 60%, and technicians and trade workers with roughly 21%. The top 3 industries here are media and telecommunications with 16%, professional, scientific and technical industries almost in the same area, 16.3%, and accommodation and food services around 12%. The top 3 states, New South Wales with almost 50%, clearly in the past year, Victoria with 25% and Queensland with 11%. The 457 visa was perceived as to be perfect for employers who wish to sponsor an employee for skilled employment in Australia in a short space of time. The application itself is a 3-stage process. It can be lodged, it would then be actually three applications which can be lodged step by step or even simultaneously to expedite the process. 3 stages are called usually sponsorship, nomination, and visa application. Moving on, the first stage is probably the first stage you as a business owner, if you run a business or if you are responsible to manage employees and to sponsor employees, you're facing the department and the department's requirements. So the sponsorship requirements are mainly the business must be lawfully registered and actively operating. It can be either in Australia or actually overseas. It doesn't even have to be an Australian business. If you represent a business from overseas, it's called an overseas business sponsorship, and you may wish to sponsor even your staff which is employed with an overseas business outside of Australia. It can be an affiliated business, a daughter company, or something like that. The department has no relevant adverse information, so the department will assess the business itself, and there are sponsorship obligations and pitfalls which will be covered later during this presentation. Training benchmarks is a topic we come across a lot in the last 3 years. Every Australian business who wishes to become a sponsor must show commitment to training by meeting so-called training benchmarks. And there are 2 training benchmarks. Training benchmark A is probably the most common one. The business must show that the recent expenditure is to the equivalent of at least 2% of the payroll of the business in payments allocated to an industry training fund that operates in the same industry as the business. In contrast, there is what is called training benchmark B. The training benchmark B is in the same area, but it's quite different. The recent expenditure to the equivalent of at least 1% of the payroll of the business must be demonstrated in the provision of training to employees of the business who are Australian citizens or Australian permanent residents. This is a topic which we can see very often becomes a hurdle. So the business who wishes to become a sponsor must make a decision during the application process. So in summary, whether to pay 2% to an industry training fund, which is the training benchmark A or A, or 1% of their payroll must be evidenced as expenses for training to employees, which is called training benchmark B. If the business and around these training benchmark topics, there are a lot of questions actually, which we face every day, almost with our clients. If the business has been trading for less than 12 months, for example, then it needs to submit an auditable training plan detailing how it will meet one of the training benchmarks. So here the business needs actually to provide a plan as part of the application process to the department, demonstrating how the business is going to meet training benchmarks. And it's of course important to make a decision here for which one the business is going to do. I'm just seeing a couple of your comments regarding my voice. Is my voice still muffled, or can you hear me now better? Just waiting here for one of you just to comment. A little better, okay. I'm trying up to speak. Fine for you? Okay, I try my best to speak a little bit louder and slower. Okay, thank you. So moving on, sponsorship requirements. If the business has been trading for less than 12 months, then it needs to submit an auditable plan, which is called a training plan, detailing how it will meet one of the training benchmarks. Former sponsors should also demonstrate they complied with their training obligations when renewing their sponsorship approval. This is an ongoing topic which we can see on a day-to-day basis. Your business, if approved as a business sponsor, must commit to a training plan, and the training plan is something which will be logged in time actually. So a business sponsorship, once it's approved, it may be approved. Your current business sponsorship may be approved for 3 years, may be approved for 4 or 5 years. It depends on the outcome of your application. But on an ongoing basis, the department can actually request approval of your commitment to be fulfilled in the last years. So this is the bullet point number 2, which becomes more and more important. Former sponsors should also demonstrate they complied with their training obligations when renewing their sponsorship approval. So the auditable training plan is not something a business puts down during an application process for the next 3 to 4 years, assuming that you as a business remain a sponsor after your first sponsorship. When it comes to your renewal application, a case officer or the department itself may actually request evidence of your training activities from within the previous period. So you need to be aware that request may become more and more common. We definitely see it more and more when it comes to our clients, that they have to provide evidence over the last 4 or 5 years. What have they done in terms of their training benchmarks, and in relation to their initially submitted training plan. Further common issues around this topic. Of course, Australian businesses, if your business is an Australian business located in Australia, must demonstrate their commitment to employing local labor, as well as non-discriminatory recruitment practices. And one of the most technical or bureaucratic issue we see are that the period for your payroll is sometimes not really aligned with the period for which expenditure are provided in terms of the percentage of a payroll. We have put on here a link, and I understand you will get a copy of this presentation in terms of the actual guidelines on what is acceptable expenditure for the 1% benchmark. You can look it up. You may find out that what you think is training for your employees, for your staff, is not necessarily what the department actually accepts as acceptable expenditure. Having said this, so the key sponsorship requirements for the business, in our view, are the business is lawfully registered and actively operating. And I'm saying this again, terms like lawfully registered So the department scrutinizes more and more your tax activities, for instance, what you have done as a business. And you need to be prepared to answer actually a variety of questions in this arena. The Australian business must also show commitment to training by meeting the training benchmarks, which we have talked about, if they have traded in Australia for more than 12 months, or to have an auditable training plan if the business has been trading in Australia for less than 12 months. Stage 2, the nomination application. Moving on now. There are 4 important topics we like to discuss today. Number 1 is the nomination of the occupation. So if the business needs to nominate a position listed on the consolidated sponsored occupation list, which is also very often referred to as CSOL, C-S-O-L. If you Google this, you find a list which is basically updated regularly by the Department of Immigration and Border Protection. There you find all eligible occupations you as an approved business sponsor are allowed to sponsor. The market salary rate, what are you going to pay your future employee, is an important topic. The approved business sponsor needs to offer terms and conditions of employment which are at least the same as those which an Australian performing the same work at the same location would achieve. Of course, the idea here is not to undercut local labor force. There's a minimum salary. The offer you must make needs to be above $53,900 per annum. And the market salary rate and the minimum salary are 2 different things. So you need to be above the $53,900, but you also need to meet the market salary requirement. And of course, the position must be genuine within the business. And you need, as the business, you need to be in a position to demonstrate that you have created a genuine position and that the business has a genuine need for that specific role. The common issues we see around this topic are in terms of the genuine position or the genuine criteria. We recommend you make sure the position description aligns with the task of the occupation. So it's probably a good idea to find out first what is actually the understanding of the department in terms of a specific occupation before you go out and write a job description. Choose the occupation wisely. Make sure the position is consistent with the nature, context, scale of the business. So if you are a sole trader and you are about to hire your first employee, so to speak, it may raise questions if your choice is a marketing manager. Maybe it's a better choice than to go for a marketing specialist or something like that. So common sense applies here very often. Provide evidence to show context of the role within the organization and why it's fit. These are 3 elements which case officers usually request businesses to do. Ensure equivalent terms and conditions of employment by meeting, of course, market salary rates and the minimum salary you need to pay, which is $53,900. It's referred to as the TSMIT or the Temporary Skilled Migration Income Threshold. It's also a good idea always to check if you have other people working in your organization at the same location or doing the same work. The department will test this question. And it's pretty hard to argue that there are discrepancies within the salary structure when it comes to Australians or non-Australians. There's something like labor market testing for certain occupations. It's always a good idea to start a recruitment process early. Try to see if an employee can be found from the local labor market in your industry within 12 months before lodging, maybe 6 to 3 months before lodging is also a good time frame. ANSCO skill level 1 and 2 are exempt from these tests, so it's always important to see to check the CSOL list or skilled occupation list whether you actually need to go through a labor market testing or whether you are exempt for a specific occupation. This is why the nomination of the role is so important. But just as a tip here, in many cases it's required, for instance, for nurses, tradespeople, engineers, these kind of nominations. The stage 3, the visa application for your future employee, has now a few aspects which need to be monitored by the sponsoring business. This is definitely our recommendation. Key requirements are, of course, you as the employer, you have an approved nomination for the chosen occupation. So the nomination has already been approved if you don't lodge applications simultaneously. The employee is employed to work in position with a sponsor. The employee has the required skills, experience, and/or qualifications to perform the role. This will be vetted by the department. The employee has a genuine intention to perform the nominated occupation. There are health and character requirements in regards to your employee. There is a health insurance requirement. Your employee must be insured privately. There are specific insurance covers available on the marketplace. Your future employee needs to speak vocational English, which basically means there's an English test requirement, and of course have a valid passport. Already at this stage, a quick note: sponsoring employers are required to pay the costs related to the sponsorship and nomination applications. However, under policy, the visa stage may be paid for by either the employer or employee. So this basically means stage 1 and 2, sponsorship and the nomination application. The costs for these 2 steps rest with the business, whilst the business can make a decision in regards to stage number 3, who is going to pay the cost for the visa application. It may be paid by the employer or by the employee. So there is a little bit of flexibility to make a cost arrangement. Yeah, and I can address that question straight away. The health insurance obligation is an obligation that usually 457 visa holders do not have access to Medicare in Australia. Therefore, they must be insured privately. The private insurance can be provided by all of the major health funds. It's a specific 457 workers health insurance. So if you go on their website and you search for the key 457 work insurance, there are specific covers which come up immediately, and your employee can then sign up for one of these covers, for instance. I hope that addresses your question straight away. Some common issues in regards to the 457 visa application itself. It's always a question whether the skills, the qualifications, and the experience of your future employee fit. It's important that you make sure you provide supporting evidence in regards to all these 3 elements. And as I said before, skills assessments for trade occupations, for many of those trade occupations, are required with TRA. Keep in mind, it's a formal process, but currently it takes up to 12, maybe even 15 weeks before the visa applicant receives an outcome of their skills assessment. A skills assessment is nothing else than a process where overseas skills, the visa applicant, or in this case your future employee, has earned overseas, are going to be transferred into an Australian equivalent. Health requirements, we talked about that, depends a little bit on country of origin and travel history. There is a separation between high risk and low risk countries. If the department requires to undergo a health requirement, which basically will be a health test or a health examination, then it may take up to 2, 3, 4 weeks before the results are available. Talking about money, I think this is the most important point from a business perspective. These are the charges you need to be aware of when applying for the 457 visa. The stage one, the approval to become a standard business sponsorship, the department currently charges you $420. The approval to become a standard business sponsorship, the department currently charges you $420 just for the what is called the SBS, the standard business sponsorship application. For each nomination application you lodge, the department charges you $330. For each visa application, for the primary applicant, that is the worker you probably want to hire, your future employee, the application charge is $1,060. Should your future employee have a partner above 18 years or older, which is called then the secondary applicant, there's another $1,060 application charge for the partner. And for every child, which is included on the application, younger than 18 years, it's $265. Remember training benchmarks. If the business is not able to provide evidence on the 1% expenditure in terms of the payroll, then there's an additional 2% of payroll donation to a training fund, which you need to budget for. Moving on, I like at this stage to ask the second actually quick poll question. Would you, exactly, you already see it. So there's almost 100% that you keep on going to sponsor people from overseas, which is good. What we find, so 94% of you actually have responded that they would like to proceed with sponsoring employees under the 457 scheme. I'm closing this poll now. What we have found is that numerous of our clients, our businesses we are talking to, are trying to overcome these issues we just talked about. The process, which is perceived as quite bureaucratic, cost expensive, unpredictable, because you all know that the 457 visa is almost on a regular basis in the news. So I like to highlight a few misconceptions here around the 457 visas before we move on. We hear a lot that the size of business or matters when it comes to a 457 application, or that there are turnover requirements like minimum profits, or the business must have made several $100,000 of turnover in the first 2-3 years or something like that. This is a misconception. They don't exist. The same as every bullet point on this page. A startup business can sponsor. So if you want to progress with a 457 application, you don't need to have an established business. Every startup business in Australia can become an approved business sponsor. The business also does not have to keep the employee until their visa expires. We hear from time to time from employers that they are a little bit careful with sponsorships in regards to the 457 visas, because there seems to be a perception, if I have somebody on a visa, I cannot let them go. I have made a commitment for up to 4 years. This is usually the validity of a 457 visa, and businesses find it difficult actually to commit to these time frames. But this actually does not exist. The business is always free to do what the business fits to be done. And it's not only selected extremely high-skilled occupations that are available. There are various occupations available under the 457 scheme. Just Google the skilled occupation list, and you will find lots of occupations which can be sponsored. And even the skills assessment, if it comes to trades, occupations, okay, but overall it's rarely required. Even formal qualifications from overseas. We hear a lot from our clients, he hasn't studied or things like that. They may only be mandatory for proposed employees depending on the occupation. But overall, they are not even strongly required, as a lot of people actually think. So even the entity itself, you can choose whether it's a company, a partnership, a trust, a sole trader. All of these forms can actually sponsor people from overseas and become an approved sponsor in Australia. So this is actually really positive on a first glance, so to speak. but you need to overcome the hurdles which the department actually puts out. We recommend, if you decide to go on with the 457 visa in the future, in the light of the current legislative changes and changes introduced by the department, take your time in selecting the nominated position. I know it's tempting to quickly decide on the nomination. You run the business, you know what the title of the new role is going to be, and probably your future employee has also an expectation. But sit together, take your time in selecting the nominated position. It may make things a lot easier for you. Provide evidence that supports your case, not just the information you first found somewhere. Ensure supporting documents don't contradict each other. You have 3 different applications at the end of the day: sponsorship, the nomination, at the visa application stage. And if you don't launch them simultaneously, and there's even a time difference in between from probably up to 1, 2, or 3 months. Ensure supporting documents don't contradict each other. We recommend you have someone else review all the documents. Get an objective viewpoint whether the business requirements actually match the nomination of an occupation you're going to choose. You are within the business, it's a day-to-day business for yourself. Have somebody else outside of the business review all the documents, whether from with the objective whether an independent person actually can understand the role within the business, the requirement for the business, from a simple common sense approach. Submissions to the department should be clear and coherent. Remember, the application is being processed by a person at the end of the day, so try to make it as user-friendly as possible. You understand everything about your business, but the case officer who is allocated to your matter, they are dealing with indefinite numbers of different business types every day, and they need to have a clear understanding actually of your business, of the nomination, and of the visa applicant to make positive decisions. Ensure the application is lodged in good time prior to existing business requirements, if possible. I know this cannot be done all the time, and we have lots of clients who actually do this on short notice, but currently the official time for a standard application, you should allow probably 2 to 3 months as a minimum before you actually receive an answer from the department. So quick overview here at this stage in regards to the 457. So there are some pros. It's relatively quickly, yes, with 2 to 3 months. Processing times after lodgement, it's still quickly compared to other visa classes. Skills assessments are rarely required, and the applicant depends on the position of the business to keep the visa valid. So there's a common let me address this later. At this stage, it's only important to know that the applicant depends on the position of the business to keep the visa valid, but on the other hand, the applicant is also free to move to other businesses with similar positions or same nominations. 457 cons. There are some fees related to the application process, and if you sponsor more than 1 or 2 people, you may find that those fees are maybe important to be budgeted for. There are sponsorship obligations, and they are quite huge and comprehensive, and Chris will introduce them to you later on. And there are ongoing changes to the 457 program, which may pose an extra hurdle to hiring processes because nobody can actually predict the future. And if you have committed yourself to the 457 program as a business, you need to be aware that whatever changes are going to be introduced to the 457 program, you need to comply. And that means, number one, A, you need to be aware of the changes, so you need to monitor the legislation on an ongoing basis, and B, you need to implement those changes, which we find is for quite a few of our clients and perceived to be an ongoing burden. This is why we want to suggest today an alternative to the 457 scheme, which we call the PR jump or the permanent residency jump. Numerous of our clients have actually sat together with us and clearly told us that the bureaucracy, the red tape, waiting time, and the challenges which we talked about today around the 457 scheme are quite comprehensive, and they ask us for another solution. And there is actually another solution. There are streamlined visa options available as an alternative to the 457 scheme, which from a business perspective, and we hear this almost every week, avoid some of, and actually most of the 457 sponsorship applications. And they are the Employer Nomination Scheme visa, the subclass 186, and the Regional Sponsored Migration Scheme visa, the subclass 187. The above two visa classes or applications, visa applications are comprised of only two-stage processes. It's only the nomination and the visa, and there is no approval as a business sponsorship required anymore. So the first step, the business approval, does not actually exist, which makes a lot of things easier for most of our clients in this area. There are a lot of benefits within these visa classes. For instance, the employer, your business is not bound to the 457 sponsorship obligations, which is, we hear it all the time, the benefit most businesses are actually looking for. There's less paperwork involved, and the employee may pay all visa application charges, and if you hire a migration agent, for instance, all migration agent fees. So you're now free as a business to actually negotiate a deal with your employee from overseas. Remember the restrictions on the 457 visa. You must not defer costs in relation to the sponsorship and the nomination to the visa applicant or anyone else. The business must cover for it. Here, under these visa classes, you are actually free to make a business decision. These two visa classes also give permanent residency status straight away to the visa applicant, which actually means they're saving money and future hassles are avoided, because with permanent residency, Medicare access comes straight away. It's actually really a goodie, a perk for your future employee, because lots of these requirements your employee needs to cover for privately, for the family, for instance, are not a problem anymore. It minimizes disruptions to your business, and most importantly, the employee and the employer are not tied together. But that comes with a good but on your end, because the employer, the business, commits to maintain the role for 2 years, not to keep the employee. Those are two different things. And in return, the employee commits to stay with the employer for 2 years. And this is a point I want to elaborate on a little bit, because we hear a lot of questions about this on an ongoing basis. On 186, 187 visa, the business only commits to maintain the role, the job, for 2 years, and it's free actually to make decisions to let an employee go straight away or not. Most importantly, in return, the employee commits to stay with the employer for 2 years, and that is a difference to the 457 visa. We find that a lot of employers are actually frustrated coming to us with a scenario where an employee on a 457 visa actually has accepted employment from a competitor or another business, and the business which sponsored the employee first is quite frustrated, because they had to cover all the expenses to bring the person into Australia, to get the visa into place, and nomination and business sponsorship approval, and then the person simply moves on to another business, which it was the case scenario is actually the competitor around the corner. And your competitor is quite happy because you did all the work, you did the bureaucracy, you had all the expenditure, the visa is in place, and then that employee can move on. Under 186 or 187 visa, that is quite difficult actually, because your employee commits to stay with you for 2 years. That gives you a certain level of guarantee actually that you are as a business in a position to make a long-term investment. You can rely on the fact that your future employee signs with the department an application committing to stay with you for 2 years. And we find this is a benefit for a lot of our businesses to go down this avenue. On top of that, there is no repeat applications necessary, because your employee is already a permanent resident. So you do it once and that was it, and your employee can stay with you as long as you want. There is no sponsorship renewal requirements anymore. You don't have to prove your expenses or to monitor legal changes to the program. These things are not required, as this is a completely different visa subclass. And of course, Medicare access to employees, including their family, from day number one, is at the end of the day a win-win situation for both of you. You save expenses, or your employees save expenses, and you can sell it even from a business perspective, taking care of your future staff. The subclass 186 and the subclass 187, there is a direct entry stream available. So you can use the direct entry stream to access both programs. It's similar to the 457. You have found somebody who's working or still overseas or working with you on a working holiday visa or these kind of scenarios. But future employee, to sum it up, can be inside or outside of Australia, does not need to hold any work visa to be sponsored by you. And what we hear a lot, the 2 years on a 457 list does not apply. So there is no such requirement. You can sponsor straight away on an employer nomination subclass 186 visa or subclass 187 visa an employee from outside or from within, inside Australia. And this is why it's so attractive. You can nominate a skilled worker. Now, to sum it up, for this visa, if you actively and lawfully operate a business in Australia and have a genuine need for a paid employee to fill a skilled position. As you can hear, this is far softer, far more in the interest of a business actually. You offer a skilled position in the applicant's field that is full-time and ongoing for at least 2 years. Once again, it's a position, it's not the engagement with a certain staff member or employee. You are free always under subclass 186 or 187 visa to make business decisions, which may include that you let an employee go. You have to let them go. The only thing matters is your commitment to keep the role intact, the position. You pay the market salary rate and comply with Australian immigration and workplace relation laws. You meet training benchmarks, and there is no adverse information known about your business or any person associated with the business. So these are all the requirements, and they fit nicely on one page. And this is probably the reason why more and more businesses actually choose to avoid what they perceive to be a heavenly burden on their day-to-day businesses, the 457 sponsorship obligations and related practical legal issues. And I think Chris will elaborate a little bit further about these.
Thank you, Alex.
These important things you have an eye out for.
Good afternoon, everyone. I'd like to talk to you about 457 sponsorship obligations. So in addition to the safety net for employees that exist under the Fair Work Act system, as well as provisions of applicable state and territory legislation, as 457 sponsors, there are a range of additional sponsorship obligations that you need to be conscious of. And someone within your organization, it's usually the HR professional, which is going to be on the front line of these issues, and certainly someone at board level within your organization should know what needs to be done in certain scenarios, know when to seek advice. They should be monitoring compliance, keeping records, knowing when to notify the department, and then actually sending the appropriate notification upon the occurrence of certain events within 28 days, which I'll come to later. The House of Representatives has recently introduced the Fair Work Amendment Protecting Vulnerable Workers Bill 2017. That was earlier this month, which provides for a higher scale of penalties for serious contraventions of certain workplace laws, increased penalties for record-keeping failures. Importantly, it makes franchisors and holding companies who have influence or control over their networks responsible for underpayments by their franchisees or subsidiaries where they knew or ought reasonably to have known of the contraventions and failed to take reasonable steps. Provisions dealing with situations where employers unreasonably require employees to make payments are also included. I'll come to this again a bit later. Strengthening evidence it's going to be strengthening evidence gathering powers of the Fair Work Ombudsman as well. So we've provided an overview here for you. Firstly, Regulation 2.79, Alex has touched on this. There's a requirement that you're providing terms and conditions which are at least equivalent to those which an Australian citizen and permanent resident would achieve performing the same work at the same location. This is an ongoing requirement. So when you're applying for the approval of your nomination, it's good to think about the terms of your employment contract. This is because it's a unique situation sponsoring a 457 employee, and some of the things that you might want to think about are, including, for example, an obligation as between you and your employee for the employee to comply with their visa conditions. The reason for this being that it'll be discussed later, for example, that your employee, if they fail to leave, for example, within 60 days of ceasing to work for you, you might be required to pay the costs associated with their removal, capped at $10,000. You might also want to make sure that there are provisions dealing with the requirement not to work for anyone else and specify the liability that this could impose upon your business. So you're putting them on notice of the effects that this could have on your business. It's a good idea to also make sure that the employee is clear on what's going to happen on termination at an early stage. And I'm talking about the contract stage, so that everyone's clear on what's going to happen, and I'll come to the reasons why later on when we discuss what notifications need to be made on termination. You obviously need to also consider whether or not an award applies, because these are going to dictate requirements regarding minimum wage, leave, hours of work, etc., and ensure that these are going to be reflected in your employment contract when you're lodging your nomination. Also remember to give the Fair Work Information Statement before or as soon as practicable after the employee starts employment. In terms of providing market salary rate, this is an ongoing requirement, and so it's therefore important for probably your HR professional to be aware of these requirements, because they're going to be keeping up to date with award reviews. And this is especially important if you're going to be paying close to the minimum. You also need to be ready to justify the rate of pay that you're paying from time to time by reference to your other Australian employees who are doing the same work at the same location. Otherwise, you can refer to things like remuneration surveys, for example. The next set of obligations deal with travel and deportation costs. Again, HR needs to be aware of the specific requirements in this regard. The practical reality is that if the employer doesn't leave, then you're going to end up paying more, or it's likely that you could end up paying more, because the Commonwealth can require you to repay costs of locating or removing your employee up capped at $10,000. So you could consider either setting out a procedure which occurs upon termination in your employment contract or in internal policies which are more easily amended in an effort to ensure that the employee is aware at an early stage and complies. Currently, the requirements in this regard are that either the primary or the secondary sponsored person needs to request in writing, or alternatively the minister can also request, make a request for payment of these funds. They need to specify the persons whose travel are going to be funded, as well as their passport country to which they want to travel. So it's got to be a country in which they hold a passport. And it's got to be made whilst you're their 457 visa sponsor. The other key requirement is that the costs have to be reasonable and necessary. And what this basically means is that you need to pay for their travel from their usual place of residence to the place of departure, i.e. the airport. The costs are for economy class air travel or equivalent, and the costs need to be paid within 30 days of receiving the written request. I touched upon the obligation to repay the Commonwealth if they have to locate and remove your employee for you. It's capped at 10,000, but the reality is it might cost the government more, and I think there's at least a moral obligation to avoid this if possible. Record keeping and notification requirements are quite important. I'll just run through these very quickly. You've got to keep a record of how you satisfied the obligations. Run through these very quickly. You've got to keep a record of how you satisfied the obligation to pay the travel costs, which I've just discussed. You've got to keep records of notification events, which I'll cover later. There are various events which are going to trigger your obligation to notify the department. You've got to keep records of the tasks which are performed by your nominee. This is basically to verify that they're doing the role that they've been nominated for. You've also got to keep records which demonstrate that you're providing equivalent terms and conditions, which I mentioned earlier, such as details of what you're paying your other employees and remuneration surveys, for example. Obviously, you've got to keep a copy of the written employment contract, and importantly, you've got to keep records which demonstrate that you're complying with the training benchmarks which Alex discussed earlier. So importantly, you need to know what payroll is, well, the definition of payroll, and also what expenditure qualifies for this, which I'll cover later. So in terms of notification to the department, this is all required within 28 days of the event occurring. Notification is made currently, the address that it's sent to is specified in a legislative instrument. At the moment you can send it by email to sponsor.notifications@border.gov.au. The events which are going to trigger notification are cessation or expected cessation of the sponsored person's employment, a change in the work duties, a change in the information in the sponsor's application for approval as a sponsor, a change in training information provided in a work agreement. If the sponsor ceases to exist, if the sponsor has paid return travel costs to enable the sponsored person to leave Australia, if the sponsor has become insolvent, and if, for example, a new partner or director has been appointed. I touched upon the requirement for the sponsor to ensure that the sponsored person actually works in the nominated occupation. When you specified the occupation at the nomination visa stage, there's an ANSCO definition which would be applicable to the role, and that sets out and defines the tasks and functions for the occupation that you've chosen. Now, the position that you've created in your organization may differ slightly to that ANSCO definition, and the position which has been approved by the department may differ slightly as well. It's important for HR to be familiar with what the ANSCO definition says for that occupation, because small changes in tasks and functions may very quickly mean that they're actually performing a different role, essentially, and you'd need to seek advice as to whether a new nomination, for example, is required. This obligation is in terms of making sure that the sponsored person actually works in a nominated occupation, is one example of how an employee's actions can actually render your business or place your business in breach of its obligations if, for example, they're doing a second job in the evenings or whatever they might be doing. And so it's a good idea to make sure your employees are clear at the outset on what they can and can't do, put obligations, positive obligations on them in the employment contract, and put them on notice of the potential impacts that this could have to your business and sanctions as a result. I'll just change the slide. 2.87 is an important provision. The policy intention underlying this regulation is that the sponsor is solely responsible for certain costs and doesn't pass on these costs to their nominees. It's reinforced by even broader prohibitions against asking for or receiving benefits, which is very broadly defined, in return for sponsorship-related events. It's basically to prevent conduct which amounts to paying for visas. Under this regulation, what it all boils down to in this regard is that you can't seek to recover, transfer, or get another person to pay for some or all of the costs associated with becoming or being an approved sponsor, or costs that relate specifically to the recruitment of a non-citizen for the purposes of a nomination. These include things like migration agent costs associated with the lodgement of sponsorship and nomination applications, recruitment costs, money associated with the sponsor meeting training requirements, pre-agreed costs that are related to attracting a 457 sponsored person, such as paying for airfares to Australia, visa application costs, moving assistance. It doesn't matter as well if the nominee actually initiates the request to pay for these things. You're still going to be in breach if you do it. Very quickly, I've mentioned as well, you've got to obviously provide the training that you said you're going to provide and keep records of that. The definition of payroll is on the screen there for you, and Alex referred to the link where you can find information about what constitutes qualifying expenditure. If you've got any questions, please get in touch with us. 2.87.
Oh, sorry.
That's okay. Just very quickly at the end, 2.87c, no discriminatory recruitment practices. This provision is basically designed to protect local labour, the local labour market, and you've got to cooperate with inspectors. So I hope this has provided you with an overview, a helpful overview of the types of measures that you can put in place to try to mitigate the risk of non-compliance.
Thank you, Chris. Much appreciated. I understand the Chamber, the New South Wales Chamber, will provide everybody with a copy by email of the slides. If there is a problem, if you don't receive them in time, just drop us an email. We are more than happy to email them straight away to you. That's basically the end of our presentation. Thank you so much for attending. I can see in the chat box that Tomomi has already addressed quite a few questions actually. If you have more, we still have a couple of minutes left. Feel free to ask or type in a text question. We are here to answer them for the remaining minutes, clearly. I want to share one question maybe with everybody before we close this off. The question was, if you were to employ a manager from our head office in the US for a specific project, would they come on a 457 visa? And we have already answered that the 457 would definitely be a good option. Clearly, on short-term assignments, the 457 is probably the preferred choice. If it's a long-term project, for instance, we see this quite a lot of power station or things like that, an infrastructure project for several years, then more and more of our clients actually opt for an employer nomination scheme visa, in particular if family members are included or involved in the relocation to Australia. There are more questions now which I'm trying to address quickly. We're transferring managing director from our German company to be managing director for our Australian company. Do we still have to prove that we try to employ within Australia? That depends on the occupation and the specific nomination. Tomomi already touched base on that one in an answer. I'm not quite sure whether you can see it. And There's another question, do you have to show you have been advertising to fill the position within Australia for a certain time frame? This is the same arena, so to say. It depends whether labor market testing is required or not. We talked about that in the very beginning. It is related to the nomination, and the decision needs to be made during the nomination stage of the application process. That is a good question. It's general time frame from start to finish for a 457 application. We currently experience responses from the department within, on average, 2 to 3 weeks. There's a possibility actually to try to expedite the process, but there's of course no guarantee. Decision-ready applications are always a good idea to expedite time frames. An application which is prepared to be decision-ready for any case officer seems to have a very fast response time. We, from time to time, receive grants within a couple of days, actually. On the other hand, the official timeframes on the department website are currently in the realm of 3 to 4 months. So businesses actually need to plan ahead. Yep. We are more than happy to provide links and more information. Just drop us, please, an email to the email addresses provided within the presentation. That is another question, and we are happy to respond to that one. I can see we are already over the time, 2 minutes past 3. I think this webinar was scheduled for from 12 to 1. We are already after 1 o'clock. So thank you for attending. If you have further questions, drop us an email to the email addresses provided. We're more than happy to respond. I'm not quite sure whether our host will say at the end something, but I think this is it from our end. Once again, thank you so much for attending.
Thanks, Alexander, Christopher, and Tamami. We've covered a lot of great information today that I'm sure our listeners will take away and implement. And thank you to everyone for participating. New South Wales Business Chamber will be in touch later with a copy of the slides and a link to the webinar on demand. Have a great afternoon.